Welcome to Juvenile Dependency, Tribal Reports, and Court Filings. The agenda for this webinar includes Introduction to I.R.A.C Model, Identification and Development of Tribes Issue, Research and Analysis of Rule, Developing Supporting Facts and Evidence, and Developing and Outlining Order or Requested Action. This webinar is intended only to be a resource tool for ICWA advocates appearing in state court proceedings. It is not intended to be a comprehensive discussion of all factual scenarios or law. Further research or analysis may be necessary, or even consultation with an attorney. So now let's shift to the role of the ICWA worker in state court proceedings. The tribe may appear by counsel or by representative of the tribe designated by the tribe to intervene on its behalf. This means that as you attend and participate in proceedings, it is up to you to develop and convey the tribe's wishes. So then, how does an ICWA advocate develop and convey the tribe's position? One model to utilize would be the I.R.A.C model. I.R.A.C stands for Issue, Rule, Analysis, and Conclusion. Issue is what is each question that the judge must answer at that hearing. Each hearing has different sets of questions. Rule: what considerations must the judge make when answering that particular question? Analysis: what are the facts and evidence needed to support that conclusion? The facts and evidence are unique to each case. Conclusion: what conclusion does the tribe want the judge to reach? So where does an ICWA advocate even begin? Well, it depends at what stage of dependency proceedings the advocate is at. For more information on the various stages of dependency, please see CILS's ICWA Advocate Guide for California Courts, which could be accessed at the hyperlink below. So how does an advocate know what issue or issues the tribe has for any particular hearing? The starting point would be to pull the findings and orders, which is a list of questions that the judge must answer at that particular hearing. These can be accessed at the website indicated on this slide. On that website, you will see a list of Judicial Council forms, which is designated as JV 410 through 457. How then does an ICWA advocate access the judicially approved Judicial Council forms? As you can see, all the forms are on the court's website. Clicking on that box will bring up a list of all Judicial Council form subjects. And in this case, you see that there's Indian Child Welfare Act Judicial Council forms. Right below that would be juvenile forms. If you click on the juvenile forms, it brings up a list of all Judicial Council forms on that subject. In this situation, we're looking for the 6-month review findings and orders. So we click on the hyperlink of JV 430. By clicking on that hyperlink, it takes you to the findings and orders for the 6-month review. In it, you can see all the questions that the judge will have to answer for that hearing. While an ICWA advocate may be less familiar with the Judicial Council forms, the advocate has seen the findings and orders before. The same language is usually included at the end of an agency social worker report as the proposed findings and orders. However, by downloading the findings and orders beforehand, the ICWA advocate is better able to review and prepare for the hearing. Let's shift back to the court's website. There are various forms that the advocate may wish to file with the court. Let's take, for example, the forms under the Indian Child Welfare Act. By changing the subject line to indicate the Indian Child Welfare Act, a list of forms will pop up. Let's take, for example, if we clicked on the hyperlink for the form for Notice of Petition and Petition to Transfer Case involving an Indian child to tribal jurisdiction. By clicking on the hyperlink, it will bring up the form on the left. On the right, you could see that the form is fillable and can be printed from online. By filling in all the blanks, all the information needed will be listed. Now that the ICWA Advocate has identified what issue or issues the tribe has for a particular hearing, how does the advocate know what rule governs that issue? As a starting point, the ICWA Advocate should refer to the ICWA Advocate Guide for California Courts by California Indian Legal Services. It can be accessed by the hyperlink below. Let's take, for example, if the ICWA Advocate was to attend a selection and implementation hearing, also known as the Welfare and Institutions Code 36626 hearing. The ICWA Advocate would decide what the issue is by referring to the Findings in Order, which is the JV 320 form. In it, let's take the example of number 12. One of the issues to be answered at that hearing would be whether or not termination of parental rights would be detrimental to the child for the following stated reasons listed below. So where does the advocate access the rule or the California law or code governing that issue? The advocate can access the rule by going to the legislature's website listed below. In it, you see that there is a link for California law. By clicking on that hyperlink listed California law, it brings up all California statutes or codes. For purposes of this example, we're going to refer to the Welfare and Institutions Code. The hyperlink is listed at the bottom right side of this slide. Once you click on the Welfare and Institutions Code hyperlink, it'll list out all code provisions under that section. We're interested in the Juvenile Dependency Code sections, which starts off at Welfare Institutions Code 300. On this page, it's listed under Division 2. So click on that hyperlink. That will take you to more specific code sections. We're interested in the judgments and orders for the 36626 hearing. On this page, that's listed under hyperlink for Article 10. And what it will do is bring us to the particular code section governing that hearing, the Welfare and Institutions Code 36626 hearing. By scrolling through that code section, you will see the exact rule governing that finding and order that we saw earlier. Let's shift now to the California Rules of Court. Because some issues also have a corresponding rule of court, it is important that the ICWA Advocate also know how to access these rules. So let's go back to the court's website. On it, you see that there is a link for Rules of Court. In it, all rules of court are listed. We're interested again in Title V, Family and Juvenile Rules. You can click on the hyperlink, and what it does is list all Family and Juvenile California Rules of Court. By scrolling down this page, what we can see is Division 2, Rules Applicable in Family and Juvenile Proceedings, Chapter 2, Indian Child Welfare Act, and what it does is it lists all the rules of court for the Indian Child Welfare Act. For example, if the ICWA Advocate was interested in transferring a case to tribal court, the ICWA Advocate would click on the hyperlink for Rule 5.483. What it does is it brings you to that particular rule. ICWA advocates must also be aware that depending on the issue, there may be a corresponding county local rule governing that issue. These local rules can usually be accessed by doing an internet key term search for your county superior court local rules. Let's take, for example, the Humboldt County local rule regarding discovery. In it, there are very specific rules practiced in that county regarding that subject. Now that the ICWA advocate has identified all the issue or issues for that hearing, knows what the corresponding rule is governing each of those issues, how does the ICWA advocate then develop their evidence or supporting facts, their analysis? What are the facts and evidence that support the conclusion or request that the tribe is making? This comes from facts already known to the tribe, tribal records, interviews. Pick 3 or 4 supporting facts for that specific issue. Then, the ICWA concludes with what order or action the tribe is requesting that the court make. So how does all this information come together? Let's do a couple real-life illustrations. Let's take a couple scenarios. Scenario number 1. Let's return to our I.R.A.C model to illustrate the issue. Let's say the tribe is asking for continuance. The rule would be, upon the request of a parent, Indian custodian, or the tribe, the court must grant up to 20 additional days to prepare for that proceeding. The citations are listed on this slide. The analysis might be that the tribe just received notice yesterday that the tribe has not had enough time to receive and review the information needed to meaningfully participate in today's hearing, and the conclusion would be, therefore, the tribe is requesting the matter be continued for 20 days. Let's take scenario 2, where the advocate has multiple issues to present to the court. Let's take the hypothetical. The tribe receives a call from Mr. Smith, who reports that his baby was detained and the dependency court made jurisdiction and disposition orders already. The baby's mother is not a tribal member. Mr. Smith is an enrolled member. The baby is not yet enrolled, but was in the process before being taken into protective custody. Although undeniably not the biological parent, mother's husband was found to be the baby's presumed, also known as legal, parent because the baby was conceived during the marriage. Mr. Smith already has a DNA test result proving that he is the baby's biological parent. Mr. Smith and mother are still a couple. It is very important for the baby to benefit from tribal services. The tribe has many services to provide the baby. The family will need transportation assistance. The tribe calls CWS CPS to ask for these additional orders. CWS CPS says that it's too late as the case plan orders were already made at the disposition hearing 4 months ago. The tribe reports that, to date, CWS CPS has never provided notice of the proceedings to the tribe. CWS CPS says it has no need to grant the tribe's request and that ICWA does not apply. So depending on the facts of the case, the potential issues for the tribe may be 5 issues to present to the court. The tribe's position may be that 1. ICWA does apply. 2. The notice was never proper. 3. That the tribe would like to invalidate all prior orders. 4. The tribe would like to request for a new case plan. And 5. The tribe would like to make a request that the court order tribal input into that case plan. How does an advocate frame the analysis? You begin by starting with a header. For example, Your Honor, the tribe asked to be heard the tribe has 5 issues to present for this hearing. First, the tribe's issue is that ICWA does apply to this matter. The rule is, ICWA applies whenever an Indian child is the subject of a state's child custody proceeding as defined by the Act. The analysis is, the fact is, Your Honor, this is a custody proceeding in that it is a proceeding being held under Welfare and Institutions Code sections 300 and following. Moreover, this child is eligible for membership in our tribe and is the biological child of an enrolled member. Therefore, Your Honor, the tribe requests that this court find that ICWA does apply. Second, the tribe's issue is that notice has not been properly made. The rule is, if the court, a social worker, or the probation officer knows or has reason to know that an Indian child is involved, any notice sent in an Indian child custody proceeding under this code shall be sent to the child's parents or guardians, Indian custodian, if any, and the child's tribe. The analysis is, Your Honor, the fact is that, to date, the agency has never sent notice to the tribe. The tribe only recently heard about the matter from the tribe's enrolled member, who is the child's father. At this time, however, the court has already entered jurisdiction and disposition orders. In conclusion, therefore, the tribe asks that this court find that notice is not proper. Third, the tribe contends that the jurisdiction and disposition orders are subject to invalidation. The rule is, if certain provisions of the ICWA are violated, including the notice provisions in 25 U.S.C. section 1912, the state court child custody proceeding may be invalidated. The analysis is, the fact is, the agency has never properly served the tribe with notice of the proceedings. The court and all parties were aware of the deficiency, as no proof of service was ever filed. Yet, the court proceeded by making jurisdiction and disposition orders. In conclusion, therefore, since notice was never proper, the tribe moves to invalidate the jurisdiction and disposition orders. The advocate would then continue with I.R.A.C.ing the remaining issues of the tribe. Now let's take scenario 3. After the ICWA advocate presents their issues to the court in I.R.A.C form, the advocate might find that their issues have been objected to. How does the ICWA advocate respond to the objections? Well, the ICWA advocate would frame the issues by providing a more detailed rule. Let's take, for example, a hypothetical. So, the tribe made a verbal request to intervene. The tribe also requested that disposition hearing be continued. CPS-CWS objects to any continuance. CPS-CWS does not specifically object to the tribe intervening in the case, but does object to the verbal request based on the lack of notice and a lack of written filed request to intervene. The ICWA advocate would begin by presenting a headliner. For example, Your Honor, the tribe disagrees with CWS-CPS's objection. Returning to I.R.A.C, the advocate might say, the issue is, Your Honor, that the tribe disagrees with the agency's claim that the intervention was improper because it was made verbally. Here, there are several rules that support the tribe's position. 1. The tribe may appear by counsel or by representative of the tribe designated by the tribe to intervene on its behalf, citing California Rules of Court, Rule 5.534, sub I. Second, it can be done orally or in writing, citing California Rules of Court, Rule 5.534, sub I. Third, the tribe and/or the Indian custodian may, but is not required to file with the court the Judicial Council Form ICWA 040, Notice of Designation of Tribal Representative, and Notice of Intervention in a Court Proceeding involving an Indian child. Again, citing California Rules of Court, Rule 5.482E. The analysis is, the fact is, the tribe notified the court and all parties of its intervention. The conclusion is, therefore, the tribe asks that the court not sustain the agency's objection and that the court accept the tribe's verbal intervention. Now let's look at scenario 4. An advocate might find that after presenting their issue, that multiple objections were made. How does the ICWA advocate respond to those multiple objections? One option for the ICWA advocate is to respond to the multiple objections by framing the issues topically. So let's return to the prior hypothetical fact scenario. The issue might be that the tribe asks that the court consider the issue of placement and services for the non-custodial parent, who is the tribal member. The rule is, when a court orders removal of a child pursuant to Welfare and Institutions Code 361, the court shall first determine whether there is a parent of the child with whom the child was not residing with at the time that the events or conditions arose that brought the child within the provisions of Welfare and Institutions Code 300, who desires to assume custody of the child. If that parent then requests custody, the court shall place the child with the parent unless it finds that placement with that parent would be detrimental to the safety, protection, or physical or emotional well-being of the child, citing Welfare and Institutions Code 361.2. Returning again to the prior factual hypothetical, the analysis might be that, Your Honor, the fact is, the father is the non-custodial parent, as the child did not reside with him when the actions that led to this petition occurred. Father has made a request for his child's custody. Placement with that parent would not be detrimental to the safety, protection, or physical or emotional well-being of the child. And in the 8 months since, Father has maintained daily unsupervised visitation, is appropriate with the child, and is in full compliance with the strict requirements of his probation. This includes random and frequent drug testing. He and Mom are no longer together, and there is no indication that they will be in the future. What you might be able to see is that these facts chosen match the elements of the rule for this request. In conclusion, Your Honor, the tribe has 4 requests. First, the tribe requests that the court declare the child to be a dependent of the court. Second, the court place the child with the child's non-custodial father, the enrolled member of our tribe. Third, that the father be provided with family maintenance services. And fourth, that the court not dismiss its jurisdiction and to supervise the family until the review hearing. As you can see, this analysis model can be utilized whether the tribe states its position in written format prior to the proceeding or verbally during the court hearing. What's important is to know any deadline or format requirements for court filings. Also know any court rules for presenting your position during the court hearing. This will conclude this webinar course. We thank you for your time and attention. For more information, please refer to www.calindian.org.